Say the name, I told him. He had already failed to answer twice. His throat moved. His fingers gripped the witness rail so hard I could see the knuckles whitening from the bench. The jurors leaned forward. The prosecutor was on his feet before I finished my sentence, objecting to a question I had not yet completed, talking over the witness, over defense counsel, over the court reporter. And then the witness looked past the defendant, not at the man accused of murder, past him, past the defense table, past counsel, straight into the second row, where a man in a navy suit sat with his legs crossed like he owned the room. The witness raised one shaking hand and said, "It's him. You could have heard a ring hit the floor." Then the prosecutor snapped, "Strike that. Too fast, too sharp." Not the voice of a lawyer protecting the rules. The voice of a man trying to put a lid on a fire before anyone saw the smoke. The businessman did not flinch. That is what I remember. Everyone else moved. The bailiff shifted. One juror pulled back in her seat. Defense counsel half rose. The defendant turned so suddenly, his chair legs scraped the tile. But the man in the navy suit did nothing at all. He just stared at the witness like men stare at something already bought and paid for. I said, "Nobody move." The prosecutor kept talking. I raised my hand once. "Counsel, sit down." He did not sit. That was the first moment I knew the case in front of me was not the case that had been brought into my courtroom. I have spent enough years on the bench to know the difference between confusion and fear, between grief and theater, between a witness who forgets and a witness who has just decided that if he does not speak now, he may never speak again. That morning, I was not watching hesitation. I was watching a man cross a line in his own mind and accept the cost. The prosecutor said, "Your Honor, this witness is non-responsive, prejudicial, and plainly unstable." The witness didn't look at him. He kept staring at the businessman and whispered, "He told me not to say it." The room broke in 3 directions at once. The gallery erupted. Defense counsel shouted for mistrial. The prosecutor demanded the jury be removed, and from the back wall, one of the courthouse security officers started moving toward the witness stand before I had ordered anybody touched. If you want to understand why I stopped that trial, understand this. When a courtroom begins acting before the judge speaks, something is rotten in the structure. I hit the bench once with the gavel. "Stop." One word. That was enough for everybody except the prosecutor. He turned toward the security officer and barked, "Take him out." Not request, order, not his authority, mine. And that, ladies and gentlemen, is when I felt the floor shift under the whole proceeding. I said, "Officer, stand down." He froze. The prosecutor looked at me like I had just interrupted a private arrangement. I looked back at him and said very quietly, "You do not run this courtroom." Now, if you've ever seen a room discover, in real time, that power has been sitting in the wrong chair, you know the sound it makes. Not noise, not silence either. Something in between, the sound of people recalculating. The witness swallowed and said, "He paid for it. He paid for all of it." The businessman finally moved. He leaned forward 1 inch. That was all. But it was enough to send another charge through the room. Defense counsel said, "For the record, let the witness identify the individual." The prosecutor slammed his palm on counsel table. "Absolutely not." I turned to the witness. "Mr. Vale, you will answer one question only. Do you mean the man seated in the second row, blue suit, red tie?" Before the witness could answer, the businessman stood, not because I asked him to, because powerful men sometimes mistake a courtroom for every other room that has ever bent around them. He said, "Judge, my attorney will address this." I said, "Sit down." He remained standing. You may think the explosion comes when somebody names the villain. Sometimes it comes when the villain forgets where he is. He took one breath like he intended to keep talking. I brought the gavel down again. "Sit down." This time he sat. The witness pointed with a trembling finger and said, "Yes, him, Victor Lang." There it was, out in the open. No taking it back, no softening it, no clever phrasing from counsel. A name, a face, a man in the room. And instantly the prosecutor moved to smother it. "Your Honor, I move to strike, instruct the jury to disregard, cite the witness for contempt, and order immediate psychiatric evaluation." That list came too prepared, too polished, as if he had rehearsed which doors to slam if the wrong truth ever reached daylight. I looked at the witness, sweat at the temples, eyes fixed, no performance. I looked at the defendant, pale, stunned, one hand still on the table like he needed to confirm the wood was real. I looked at Victor Lang, calm again, too calm. Then I looked at the prosecutor and asked the question that changed the trial. "When did you first learn that name?" He blinked once. "Excuse me? When did you first learn that name?" He said, "I learned it when the witness blurted it out in this courtroom." A clean answer, fast, almost respectable, and false. I did not know it yet, but I felt the lie pass through the room like cold air. If you stay with me, you'll see why that answer mattered more than the accusation itself. Because trials are not destroyed only by guilty men. They are destroyed by people who decide the truth is inconvenient. I ordered the jury out. The prosecutor objected. I ordered them out again. They filed through the side door with that strange, rigid discipline jurors adopt when they know they have just seen something they were never meant to see. One woman in the front row of the box kept turning back toward Victor Lang until the bailiff guided her through the door. Then I cleared the gallery. The businessman's attorney had appeared as if from the wall. Expensive suit, expensive voice, expensive impatience. He announced his representation before I acknowledged his presence. I let him speak 8 words. Then I cut him off. Your client is not a party in this case, he said. He is now the subject of slander in open court. I said, then he should be very interested in silence while I determine whether it is slander. Defense counsel nearly smiled. The prosecutor did not. The witness asked for water. A clerk moved toward him. The same security officer moved too. Too quick again. Too eager. Not you, I said. He stopped. A clerk I trusted brought the water instead. That was promise number 1, though the room did not know it yet. Once I see a pattern, I do not let it go. The witness drank with both hands. Then he looked up at me and said, if I say the rest, I'm dead. Nobody in that room answered him. Not the prosecutor, not the businessman, not the officer who had twice moved before direction. Nobody. So I did. Not in here, I said. The prosecutor laughed once under his breath. It was not humor. It was disbelief. He still thought the machinery around him would hold. I asked the witness, did Victor Lang order the killing? The prosecutor stood. I invoke privilege and due process concerns as to this line. I said, you don't invoke privilege for a witness you don't represent. Sit down. He sat, slow this time. The witness said, I heard the order. From whom? From Lang. Where? He looked toward the floor. At the Port Meridian Club. That name brought another shift. Small if you were not watching closely. Huge if you were. Defense counsel looked at the prosecutor. The prosecutor looked at the wall. Victor Lang looked at nobody at all. You learn after enough years that certain places arrive in testimony with their own weather. The Port Meridian Club was one of them. Private memberships, political money, men who laughed softly because they never needed to raise their voices. The kind of place where favors were stored, not requested. The witness said, the defendant wasn't supposed to be there. I leaned forward. Explain. He looked at the defendant, then back at me. He was the driver. He got called in that night. That's all. He heard something. They panicked after. The defendant finally spoke, hoarse and stunned. I told them I didn't kill anyone. His own lawyer put a hand on his arm to quiet him, but the line was out now, and it landed hard because it was not dramatic. It was plain. Plain words are dangerous in a corrupted room. The prosecutor shot back. Your Honor, this is fantasy built on hearsay from a compromised witness with incentive to redirect culpability. Maybe, maybe not. Courts do not convict on instinct. But neither do I ignore a witness when every powerful person in the room tries to shut his mouth before the sentence is finished. I asked the witness, why speak now? He answered with the only honest thing said in that courtroom all morning. Because he's here. He did not mean me. He meant Lang. That was the second promise. If the man had come to watch, then he had come for a reason. Powerful men do not attend random trials. They attend proceedings they expect to control. I want you to notice something. Up to that point, I still had no proof the businessman ordered a murder. I had no proof the prosecutor knew him. I had no proof security was compromised. All I had were timing, behavior, resistance, and one frightened man taking a risk nobody in his position takes unless the alternative is worse. That is enough to pause a train. It is not enough to decide the destination. So I started asking narrow questions. Mr. Vale, did you previously give a statement to police? Yes. Did you name Victor Lang? No. Why not? They told me not to. Who? He opened his mouth. The prosecutor rose. At the same instant, the businessman's attorney rose. At the same instant, that same security officer stepped forward again. 3 men moving to stop one answer. That is not coincidence. That is choreography. I said, everybody sit down before I have badges and barcodes on my desk by noon. They stopped. The witness said, Detective Rowan and the prosecutor. Nobody breathed. Defense counsel said, Your Honor. I silenced him with a look. The prosecutor's face changed then. Not much, but enough. The righteous anger drained off. What remained was calculation. Men show themselves when the first mask fails. He said, This is outrageous. I said, That depends entirely on whether it is true. Then he made his mistake. He turned to the witness and said, "You were promised immunity, and you know it." The witness stared back. "No, I wasn't." The prosecutor closed his mouth. "Too late. You may miss why that mattered, so let me make it plain. Nobody had mentioned immunity in that room. Not me, not defense, not the witness. Yet the prosecutor reached for it instantly, like a man grabbing the folder he thinks is still hidden under the desk. He had just revealed knowledge of a conversation he claimed never happened. That was the third promise. And now I had a string to pull. I asked, "Counsel, when exactly did immunity enter your mind?" He said nothing. I asked again. He said, "It was hypothetical." "Good," I said. "Then hypothetically, you'll hand over every note, memorandum, and communication regarding witness negotiations, formal or informal, by close of business." Victor Lang's attorney objected that his client was being defamed. The prosecutor objected to compelled disclosure. Defense counsel demanded dismissal. The witness said, "Don't send me back out there." Every corner of the courtroom wanted a different fire put out first, so I chose the one no one expected. I called for the courthouse camera logs. That drew the first visible reaction from Victor Lang. Just a turn of the head, just enough. You see, when people construct a lie around testimony, they prepare for words. They do not prepare for hallways, elevators, entrance time stamps, private meetings in public buildings. They forget buildings keep secrets better than people do. The clerk hesitated. "Your Honor, that may take time." "I have time," I said. The prosecutor did not want me to have time. That was his problem. He asked for a recess. I denied it. He asked to confer privately with the witness. I denied that too. Victor Lang's attorney asked for a protective order on behalf of a non-party. I told him he could file whatever paper he wished after he stopped talking. And then, because I wanted the pressure exactly where it belonged, I asked the witness one more question. "Mr. Vale, why did Lang come to court today?" The witness looked right at him. To make sure I stayed with the story. If you've watched enough trials, you know some sentences do not end when the speaker stops. They keep moving, landing in different places. That one landed on the jury room door, though the jury was no longer inside. It landed on the defendant, who bent over and covered his mouth. It landed on the prosecutor, whose tie suddenly seemed too tight. And it landed on me, because once that allegation was spoken, any decision short of intervention would be a form of permission. Now let me tell you about the defendant, because up until then, the system had done what it so often does to the poor and the replaceable. It had turned him into furniture. He had a name, of course, Daniel Ruiz, 26, commercial driver, no history of violence, one prior arrest for unpaid fines that never resulted in conviction. He had been sitting 6 feet from the center of the storm and might as well have been invisible until a witness looked past him and pointed to money. That is how scapegoats are made, not with genius, with convenience. I did not say that in the moment. Judges who preach too soon stop hearing the room, but I thought it, and once I thought it, I could not unknow it. If you think the next move belonged to me, you're wrong. It belonged to the people trying to stop what had started. A court officer entered from the side door and approached the clerk with a note. The clerk passed it up. I read it once. "Bomb threat to courthouse annex. Recommend immediate partial evacuation." Timing is a language. The prosecutor said, "For everyone's safety, we should adjourn." Of course we should. Maybe the threat was real, maybe not. Either way, the pressure point in the morning had arrived exactly when the chain of custody, witness intimidation, and hallway logs were about to come into reach. I asked, "Who made the call?" No answer yet. I asked Security Command to verify. The same officer who had moved toward the witness twice said, "Judge, we need to clear this room now." Need. Again the language of someone who had forgotten whose call it was. I looked at him and said, "Step back from the witness stand." He said, "Sir." I said, "That was not a request." He stepped back. Then I ordered the courtroom sealed, not cleared. Doors secured, no movement of parties, no removal of the witness, no private contact by counsel, no access to the holding cells, and no one leaves until I have confirmation from independent command. The prosecutor objected so loudly he nearly cracked his own voice. That was the fourth promise fulfilled. When the room moved wrong, I stopped the room. You may be wondering whether that was risky. Of course it was risky. But do not confuse risk with recklessness. I did not hold people in danger. I held them in uncertainty while I checked whether danger had conveniently arrived to rescue a collapsing prosecution. 10 minutes later, verification came back. No bomb threat to the annex, no call logged, nothing. The lie had reached my bench wrapped as emergency procedure. I turned slowly and looked at the security officer. "What did you just try to do?" He did not answer. "Who told you to move that witness?" Silence. I ordered his badge surrendered on the spot. Now the courtroom truly divided. Half the room realized this had gone beyond a witness-changing testimony. The other half was still gambling that rank, connections, and procedure might save them if they held the line long enough. Victor Lang's attorney demanded the officer be allowed counsel. Counsel will be available to him, I said, after he stops wearing that badge. Then defense counsel, smelling daylight for the first time all trial, asked for immediate dismissal with prejudice. I denied that too. Not because Daniel Ruiz did not deserve relief. He did, but because I was no longer only protecting one defendant. I was preserving a record before contaminated hands could rewrite it. A rushed act can free one innocent man and still lose the larger truth. Remember that. Justice is not speed. Justice is control under pressure. The clerk returned with preliminary camera logs. Not full video yet. Enough to identify entries. Victor Lang had entered through a judge's side corridor 43 minutes before court, escorted not by public security but by Detective Rowan. The prosecutor had entered through the same corridor 7 minutes later. The witness had been brought in early and held not in the standard waiting room but in interview room C. 3 guesses who signed that transfer. Detective Rowan. Now the air in that courtroom changed from accusation to structure. The witness was no longer the only piece making noise. The building itself had started speaking. I read the times aloud. The prosecutor interrupted. There are innocent explanations. There often are, I said. That is why I prefer records. Victor Lang's attorney said his client had come through a side entrance for privacy. I asked who authorized it. He said he would need to check. I said, you should have checked before he used a restricted corridor on the morning he was identified in a homicide trial. The witness suddenly blurted, interview room C. That's where Rowan told me Daniel takes the fall or my sister disappears. Defense counsel whispered, Jesus. I did not. Judges keep their faces when rooms collapse, but my hand closed around the edge of the bench hard enough to feel the wood bite back. I asked, did anyone record that interview? The prosecutor answered first. No. Too fast again. I turned to him. I wasn't asking you, the witness said. There was a camera, but Rowan covered it with his jacket when he came in. The clerk looked at me. The bailiff looked at me. Even the court reporter paused before catching up, because now we were no longer discussing a dirty case. We were approaching an organized one. If you've made it this far, don't go anywhere, because what happened next is the part even seasoned lawyers in that room never saw coming. I ordered Detective Rowan brought to court immediately. The prosecutor objected on grounds so scattered they sounded assembled mid-sentence. Pending investigation. Improper summons, officer safety, witness contamination. He threw sand because he had run out of bricks. I overruled him. 15 minutes later, Rowan entered in plain clothes with the expression of a man who had not yet been informed that the script had changed. He walked with the confidence of somebody accustomed to rooms yielding. Then he saw Lang. Then he saw the witness. Then he saw me looking at the camera log in my hand. Only then did he slow down. I did not waste words. Did you escort Victor Lang through a restricted corridor this morning? He said. I don't recall. Do you deny it? I said I don't recall. The prosecutor stepped in. Your Honor, my office needs an opportunity to advise, I said. Your office has advised enough. Rowan looked toward him anyway. Tiny glance. Quick, fatal. That is the thing about conspiracies. They rarely collapse from one grand confession. They collapse from habits. A glance, a rehearsed interruption. A lie told too early. I asked Rowan, did you place the witness in interview room C? Yes. Why? Security concern. Whose concern? He said nothing. Did you threaten the witness's sister? No, the witness shouted. You said she works late on Fulton and accidents happen. Rowan looked at him with the disgust of a man angry that prey has learned speech. That look told me more than his answer. Then came the blow I had been waiting for without yet knowing its shape. The clerk handed me a note from records. Interview room C did have camera coverage, but the feed for that morning had been manually archived under administrative hold at 8:14 a.m. Administrative hold requires authorization. By policy, one of 4 signatures. Chief clerk, presiding judge, security administrator, prosecutor of record. I had not signed. The chief clerk had not signed. The security administrator was not even in the building yet at 8:14. That left one chair. I looked at the prosecutor. He looked back, then away. The whole room understood at once. This was no longer a witness credibility dispute, no longer a surprise accusation, no longer a wealthy man's name thrown like a stone into a murder case. It was an active contamination of a criminal proceeding by people entrusted to protect it. Defense counsel asked, very softly now, Your Honor, what is this court's order? That is the line. The one everybody waits for, in stories like this. The line people think is dramatic because it is loud. But power, real power, is often quiet. I said, "This trial is suspended." Nobody moved, I continued. "The jury will be sequestered and instructed to draw no inference from the suspension. The defendant will be remanded not to standard holding but to protective judicial custody pending emergency review. The witness will be placed under independent protection outside the chain of local law enforcement. Detective Rowan is to be detained pending internal affairs and state investigator review. The officer who attempted witness removal is relieved. The prosecutor is removed from further participation in this matter, effective immediately." That was when Victor Lang stood again, not in outrage, in desperation. "You can't do that over one criminal's word." I turned toward him. "No," I said. "I did it over everyone else's behavior." And that, right there, was the hammer. But the story did not end with the sound. It rarely does. Lang's attorney started talking about appeals, defamation, abuse of discretion, political theater. I let him spend himself. Every extra word made him sound less like counsel and more like a man trying to delay the locking of doors. Then Daniel Ruiz did something I did not expect. He stood, despite his lawyer tugging at his sleeve, and looked at me like he had been underwater for months. He said, "Judge, if you stop now, they'll still get me later." That line stayed with me, because innocent people who have been fed into bad machinery do not celebrate when the machinery pauses. They know better. They know systems can restart. They know names on paper can outlive truth in the room. I said, "Not this time." Again, not a speech, not a promise to the cameras, just a ruling shaped like a sentence. We recessed under seal. State investigators arrived before sunset. They took the archived hold records, corridor logs, courthouse communications, and eventually the recovered footage from outside interview room C. Not inside. That camera had indeed been blocked. But outside showed enough. Rowan entering, prosecutor entering minutes later, Victor Lang's assistant arriving with an envelope, the security officer pacing the corridor, people who had no legitimate business orbiting a witness in a murder trial like planets around a dark sun. Within 72 hours, the murder case against Daniel Ruiz collapsed, not with fanfare, with paperwork. Sometimes that is the most brutal form of truth. Quiet documents undo loud lies. Charges were dismissed without prejudice first, then never refiled. A grand jury began hearing evidence on conspiracy, witness tampering, obstruction, and subornation of perjury. The prosecutor resigned before disciplinary proceedings could complete. Rowan was indicted. The security officer cooperated after his suspension and admitted he had been instructed to remove the witness if testimony went off script. His words, not mine. And Victor Lang? He did what powerful men always do first. He denied access, denied meetings, denied knowing the witness beyond casual charity events, denied the side entrance mattered, denied the envelope, denied the pressure, denied the dead man ever had business disputes tied to his companies. Then records came in. Phone records, club logs, vehicle pings. Financial transfers routed through a consultant so sloppy it might have insulted me if the stakes were not so grave. The state built its own case, slowly, properly, with the kind of patience corruption mistakes for weakness. Months later, Victor Lang was charged, not because one witness pointed at him, because once that finger lifted, every person who rushed to push it down exposed a piece of the machine. That is the lesson. Evil rarely enters court wearing a sign. It enters with credentials, tailored clothing, procedural objections, and a practiced tone. It sits in the second row like it belongs. It smiles at the right people. It counts on exhaustion. It counts on fear. Most of all, it counts on everyone treating each irregularity as separate from the next. A covered camera, a side corridor, a rehearsed objection, a false emergency, a nervous witness, a convenient defendant. Taken alone, each can be argued. Taken together, they tell you exactly what you are looking at. You may be asking what happened to the witness. He lived. That matters. He entered protection, testified again under controlled conditions, and for the first time told the story without Lang in the room. It was not pretty. Truth often isn't. He had participated at the edges. He had kept quiet when he should have spoken. He had bartered his courage until the price rose too high. But the law knows the difference between a stained witness and a false one. And Daniel Ruiz? He walked out of custody, a free man, carrying a paper bag with his things, same as thousands before him. Except he walked out knowing how close he had come to disappearing into somebody else's plan. Later he filed civil claims. He should have. The state cannot take months from a man's life through corruption and then ask for grace. Do I remember the murder victim? Yes, I do. Because somewhere in these stories people start speaking as if the fight is only about power and innocence among the living. It is not. A dead man cannot object when the wrong body is placed in the defendant's chair. He cannot raise his hand when the wrong story is read into the record. The court owes him truth too. That is why I am telling you this now, not to dramatize a courtroom. Courtrooms do not need help being dramatic. Put enough fear, money, grief, ego, and law in one room and the sparks come on their own. I am telling you because many people still believe justice fails in grand cinematic ways. Sometimes it does. More often it fails in administrative ones. A form pulled early, a file held back, a witness redirected, a hallway used by the wrong shoes. If nobody notices, the case proceeds, the jury deliberates, the verdict is read, and everyone says the system worked because the furniture remained upright. I have never been impressed by upright furniture. I care whether the room is honest. On that day, honesty nearly died in front of me. Not from one lie, but from the speed with which respectable people moved to protect it. And yes, I think about the exact second it turned. Not when the witness said the name. Earlier, when the prosecutor tried to strike the answer before the room had even heard it. That reflex told the truth first. The witness only confirmed it. If you ever want to know where to look when a story is being buried, don't look first at the person speaking. Look at the person panicking. That day, panic wore a prosecution badge. I have presided over enough cases to know I am not the hero of every story that enters a courtroom. Judges arrive late. The damage usually begins long before we sit down. But we are responsible for one thing without excuse. When the lie reveals itself, we must not help it survive. I did not help it survive. I stopped the trial. I ordered the investigation. I broke the rhythm they were relying on. And because I did, a man they had prepared to sacrifice lived long enough to see the state admit what had been done to him. That is not perfection. It is not redemption for every wound in the system, but it is a line held, and sometimes, in law as in life, a line held at the right moment changes everything that follows. So when you hear somebody say, courts are only paperwork and routine, remember this one. Remember the witness gripping the rail. Remember the businessman in the second row. Remember the prosecutor trying to outrun a name. Remember security moving before the judge spoke. Remember the false threat. Remember the camera hold. Remember the corridor log. Remember how many people had to act in concert just to keep one dangerous sentence from breathing in open air. Then remember this, they still failed, because all corruption, no matter how polished, contains one fatal weakness. It assumes the next person will look away. I didn't, and when I said stop, everything stopped.